Let's take a look at the Fifth Amendment. The Fifth Amendment gives us a ton of rights. And some of them are quicker and easier to go through, and some of them are harder. So let's start with the first part. And the first part says, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of grand jury. What this means is that it's dealing with being charged. And an indictment, the term indictment means to be officially charged with a crime. Sometimes when people hear the word jury, they think of, oh, I already know this. This is the jury that determines guilt or innocence. But that's not what a grand jury does. There's two types of juries. The jury that we're thinking of that determines guilt or innocence is known as a petit jury. The grand jury plays a different role completely. All they do is charge somebody with a crime. They meet prior to the trial, after the arrest, and it's early on in the stage. They determine if there's enough evidence to actually charge the person with the crime, and then if there is, they issue an indictment, which is an official charge. And if that person is charged with the crime, then eventually they will have to plead either guilty or not guilty. And if they plead not guilty, they'll eventually get a trial, and in that trial, another jury, this time a petit jury, will determine if they're guilty or not. So a grand jury just means that it's not the government that actually charges us with a crime. It is the people, a people's jury or a grand jury. And that's all it means by that. The next right found within the Fifth Amendment deals with what we call our double jeopardy. And what double jeopardy protection is it protects us from being tried twice for the same crime. If somebody is tried for a crime and found not guilty, we call that to be acquitted. If they're found not guilty, they can never be tried for that same crime again. It protects us from being tried over and over and over and over again by the government. Some things that are not double jeopardy are, let's say, multiple offenses. Let's say that somebody plants a bomb and it kills 3 people. You could be tried 3 times. Once for killing person number 1, once for killing person number 2, once for killing person number 3. That's not a violation of double jeopardy because that's not the exact same crime. Killing a person number 1 is not the same crime as killing a person number 2. However, if the person was tried for killing all 3 in one trial, then he was being tried for killing all 3 at once. So it kind of depends on the trial. A mistrial, one that ends without a verdict or is declared a mistrial, you can be tried again because the first trial never counted. But what double jeopardy protects us from is being tried more than once for a crime. The government has one chance to find you guilty. If they don't, you can never be tried for that crime again. Another right within the Fifth Amendment is our protection against self-incrimination, or being a witness against ourselves. What this basically means is the defendant never can be forced to answer any question, even by the police. So if you're arrested for a crime and the police are asking you questions, you have the right to answer questions, but you also have the right not to. So, excuse me, you can refuse to answer any questions. You can refuse to take the stand in a trial. The only person who does not have to take the stand in a trial is the defendant themselves. They can never be forced to. They can waive that right and take the stand if they want, but they can't be forced to. Now, if a person is being questioned by the police, they certainly can answer questions. They don't have to remain silent. And those confessions can be used in court as long as they aren't coerced. So you have the right not to speak, not to answer questions, but you can. And if confessions aren't coerced, they're usable in court. Coerced means, well, here's a definition. The use of threats or violence, intimidating behavior to put a person in fear, to get them to answer questions. So if I would ask you questions, let's say I'm a police officer and I'm asking you questions and you refuse to answer, so I start beating you and all of a sudden you start answering questions, that is not a freely given confession. That is a coerced confession. Now remember the exclusionary rule from the Fourth Amendment. Any evidence obtained illegally can't be used in court. Well, that applies to confession. If a confession is coerced, it is not that the statements, that confession is evidence, and that evidence was not freely obtained, so that can't be used in court. Sometimes people have a misunderstanding of what exactly this means, especially when it comes to like the Miranda rights. I have a lot of questions on that. Well, Miranda stems from this right, and it actually comes from the case Miranda versus Arizona. Ernesto Miranda was a man who was accused in March of 1963 of kidnapping and raping an 18-year-old girl. And Miranda was arrested and he was questioned for 2 hours. Now, he wasn't beaten, he wasn't tortured, he wasn't coerced in any way. He was just questioned by police, and he confessed to the crime. He later wrote down his confession. He actually pointed out the victim and said, that is the girl that I raped. So he confessed to this crime. And Miranda was tried, and his confession was used as evidence in court, along with other things. There was a witness that saw him driving a vehicle. The victim themselves could identify Miranda, but the confession was also used, and Miranda was found guilty. Miranda appealed, though, and it went to the U.S. Supreme Court. And in the U.S. Supreme Court overturned the conviction because they said that Miranda's confession was not freely given. Even though he wasn't coerced in any other way, the Supreme Court said that custodial interrogations are inherently coercive, meaning by their very nature, if you're being interrogated by the police, that is coercion. Miranda said that he did not know his Fifth Amendment right to remain silent. He didn't know he didn't have to speak to police. The Fifth Amendment doesn't say that you have the right against self-incrimination and you need to be informed of it. But the courts ruled that that's essentially what it means. And they said from this day forward that Miranda rights would be required to be read at the time of the arrest. Now, there's some more things I need to talk about, but these are the Miranda rights. You have the right to remain silent. Anything you say can and will be used against you in court. You have the right to talk to an attorney. This part of the Miranda rights actually comes from a second case, Gideon versus Wainwright, that happened previously. So the Supreme Court wrote these Miranda warnings and said that at this point, you need to, from now on, the Miranda rights are required when arresting somebody. Now that's kind of an oversimplification, because really those rights don't always have to be read. The court said that custodial interrogation, well, what that means is that you are in custody and you are being questioned, then the Miranda rights are required. So custody would be not necessarily pulled over by police for a speeding ticket. That's not necessarily custody. But let's say you're in jail or handcuffed or whatever. That's custody. And you're being questioned. Someone's asking you questions. Your Miranda rights need to be read. So let's say that you're arrested. You put in the back of the police car with handcuffs on. And the police are in the police car and they say, what were you doing? And you say, well, I just robbed the place. Okay. Your Miranda rights were not read. They should have been, because you were in custody and being questioned. The Miranda rights were required at that point. However, let's say that the police knock on your door, ask if you can come in, they say yeah, and you are sitting at your living room, and they say, can we ask you some questions? Well, sure. So you ask, what did you do last night? And you say, well, I robbed the place. Okay. Miranda rights were not required. You were not in custody. You were being questioned, but not in custody. Or let's say that somebody's arrested, they're in the backseat of the car, they're handcuffed and so on, they're driving to the police station, police officer's not saying a word, and all of a sudden the person just starts confessing to crimes. Again, Miranda was not required because the person was not being questioned. Both custody and questioning are required. So what does that mean? Well, if you were in custody and being questioned, your Miranda rights needed to be read. If your Miranda rights were not read under those circumstances, you're not innocent. You're not free to go. It just means that what was said is not usable in court, that was essentially coerced. So if there's all kinds of other evidence against you, they could still get a conviction. They just can't use your confession. And that's exactly what happened to Miranda. Miranda was given another trial. Because the first trial was determined to be a mistrial, it's not a violation of double jeopardy. Miranda was tried again, and this time his confession was not used, but the other evidence was, and Miranda was found guilty. A lot of people have misunderstandings of exactly how the Miranda rights work, but keep in mind, both of these elements, custody plus question, are required, and it is tied to the right against witnessing, being a witness against yourself. That's where it originates from in the Fifth Amendment. Also in the Fifth Amendment, we have the Fifth Amendment says that we can't be deprived of life, liberty, or property without due process of law. Now, we do execute people in the United States occasionally, so that is depriving somebody of their life. Anybody who's in freedom, or in prison, excuse me, is deprived of their liberty, which is their freedom. Or if you've been fined, you've been deprived of your property. So it doesn't, the Fifth Amendment doesn't say you can't be deprived of life, liberty, or property. It says they can't be deprived of those things without due process of law. So the real question is, what is due process of law? And due process of law means that all of the rules that are followed, that are established by the government, must be followed. So there's a process that has to go through, and a simplification is you must have a grand jury indictment. That's one part of the process. You must have a fair jury. That's another part of the process. You must have a jury trial, or at least the opportunity to have one. That's part of the due process. Okay? Whatever steps are established either by law or the Constitution have to be followed. And if they are, then you can be deprived of your freedom, your life, or your property. It also means the laws themselves must be fair, treat people equally. That's called substantive due process. Just here, the first part is known as procedural due process. But that's what due process means. Nor shall private property be taken for public use without just compensation. Now, this is part of the Fifth Amendment that doesn't deal with criminal law, but it does deal with your land. And the government has eminent domain, which means the right of all lands within their jurisdiction. This is not protecting us from the government never taking our land. What it does is protects us from the government from taking our land for no reason. What this says is that it must be for public use and you must be justly compensated. The government does occasionally take land from people. They need to build an airport or expand a highway or something like that. They'll try to buy the land from the individual. If the individual refuses to sell it, the government can take it. But it has to be for the public use, which think of airports are for public use, or roads are public use, stuff like that. And they have to pay you whatever the fair market value is. That's a just compensation thing. A more recent Supreme Court ruling in 2005, the Kello versus City of New London, basically said that public good is equivalent to public use. This is a relatively controversial ruling, but the Supreme Court basically ruled that if the government can prove that there is a public good for taking the land, and you are just compensated, that is sufficient to take the land. That's different than public use, because maybe it's not for the use of the general public, but it's for the benefit of the public. Controversial ruling, but I think we almost have to change public use to public good based on that interpretation. Again, kind of a controversial court ruling, but nonetheless, that was a ruling. So the Fifth Amendment gives us a number of protections. It doesn't protect us from the government taking our land. They can't take it for no reason. It doesn't protect us from going to prison. It just protects us from going to prison without our due process. So it gives us a number of those protections. The Sixth Amendment we're going to cover too. And the Sixth Amendment gives us a bunch of things, and all are dealing with the rights of the accused. Most of these are pretty simple. The Sixth Amendment gives us these rights. The right to a speedy trial, which simply means that if arrested, we can't be held in jail for years awaiting a trial, that it must come relatively soon after the arrest. The right to a public trial, meaning it's open to the public. It's not held behind closed doors, but it's open to the public where people can observe and watch and make sure that the government is not violating any of our rights. A local trial means that it's going to happen, the trial is going to be held in the area where the crime was committed. In South Dakota, if you commit a crime in Minnehaha County, you're going to be tried in Minnehaha County. An impartial jury. An impartial jury is an unbiased jury, a jury that doesn't have any leanings towards guilt or innocence. And there's got to be a process of choosing that, and that process is known as a voir dire. So your jury is going to determine if you're guilty or not. That jury should not believe beforehand that you're guilty. They shouldn't have a prejudice against you because of your race or anything like that. They really should be a blank sheet of paper, and just the evidence that comes forth, then they can make their decision. So if somebody, so there's a process. So the jury selection process or the voir dire, they'll call in potential juror members. They'll ask them questions, and they're trying to determine, do you know anybody in this case? If you're a potential jurist and you're a friend of the victim, you would not be impartial. Or if you're a friend of the defendant. Or if you read a lot about this in the newspaper, watched it on TV, and you have some kind of preconceived notion on guilt or innocence, you're not impartial. And you shouldn't be allowed to be on the jury, and you wouldn't be. If you are prejudiced towards, let's say the defendant is a Native American, and you're prejudiced against Native Americans, maybe you can't be impartial. There's a number of things that may make somebody, that would exclude them from being a jurist. And you have the right to a jury that is impartial, unbiased. You have to be informed of the charges. If you're arrested of a crime, how can you defend yourself if you don't even know what you're being charged with? So it seems like, well, duh, this seems really simple, but these are important rights that we have. You have the right to confront witnesses against you, meaning that there's no secret witnesses in court, and you have the opportunity to cross-examine any witness that is presenting evidence in court. You have the compulsory process to have witnesses on your behalf. You can force someone to be in court and present evidence for you. Maybe somebody can vouch for you. Maybe you're charged with a crime that happened at 10 o'clock at night on November 17th. Well, at that 10 o'clock at night, you were with somebody. You were on a date with somebody. And they can verify that. But they don't want to come to court for whatever reason. Maybe you had a bad breakup and they don't want to testify on your behalf. You can force them through compulsory process to come to the stand. Through a subpoena, you can get them to court, and then they have to tell the truth while on the stand. That's your right to make sure that witnesses appear that have some knowledge on this case. You want the full picture presented before that jury. You have the right to a lawyer. And if you can't afford a lawyer today, you can have one. Now, the Sixth Amendment says we have the right of assistance of counsel, which means a lawyer. We've always had this right, but there was a pretty big case called Gideon versus Wainwright that happened in 1963. Earl Gideon was arrested for a break-in at a pool hall in Florida. And Gideon was poor, and he asked for a lawyer, and they said, well, you can have one if you can afford one. He said, well, I don't have any money. And they said, well, I guess you're just out of luck. So Gideon had to defend himself in court, and he was found guilty. But he eventually appealed, and it went to the U.S. Supreme Court in 1963. And he said basically his right to an attorney was violated because he couldn't afford one. And the Supreme Court agreed with him. They said that that an attorney or a lawyer is a necessity, not a luxury in court. And they said from this day forward that if someone can't afford an attorney, that the government would have to supply one for them. This completely changed our legal system. All of a sudden now we have a public defender's office in both the federal in the states. Gideon was given a second trial now, and this time with a lawyer, he was found to be not guilty of this crime. This happened prior to the Miranda case, and if we go back to this Miranda ruling, if you remember the Miranda Rights, the first part deals with the Miranda case. The second part, you have the right to talk to a lawyer and have them present. If you can't afford a lawyer, one will be appointed to represent you. This was from that Gideon case. These are two very big criminal law cases that happened in the 1960s. And they were both combined into the Miranda Rights. All of these rights that are found within the Sixth Amendment, all of these rights are to better guarantee a fair trial. And if so think of these as all your due process. All the stuff, a speedy trial, public trial, local trial, impartial jury, and so on. This is your due process. And if you're given all of these things and you have a fair trial and you're convicted, then the government can punish you. However, you can't be denied any of these things. These are known as the rights of the accused. A lot of things in the Fifth and the Sixth Amendment, most of us never use directly, but indirectly they protect us from the government.